The top two.
For the delay, we just have some new security factors I have to make sure and use. All right, so we have just one case on the docket this morning. That's 2016 CF 2013, State of Florida versus Samuel Mosley, who's here and represented by Mr. Harper. Ms. Basso, you're here for the state?
Yes, I am, Your Honor.
Okay, I think we're here just kind of for a little bit of a status conference to figure out everything that we need so we can give Mr. Mosley his post-conviction hearing that he's requested. We were here, I think, about 2 weeks ago, and there was some confusion, and I think we needed to kind of make sure we had everything set up because, as I think I said last time, Mr. Mosley, I want to make sure you have a fair bite at the apple here and not kind of piecemeal this and keep coming back and keep coming back. So, Mr. Harper.
Judge,
what's the status from your side?
With respect to Mr. Mosley, Rudy Harper, for the record, on behalf of Mr. Mosley, he's provided me a list of witnesses that he wants subpoenaed. This is a much more manageable list, and we've gone over why these specific individuals will be subpoenaed. I'm stating on the record that I will subpoena those individuals for the next hearing.
Okay.
I'm not.
Well, one thing that came up, and I'm sorry to interrupt you, Mr. Harper, but in my discussions with our staff attorney, and looking through his motion, I think there were 6 or 7 specific witnesses that were listed as to people that he wanted to have subpoenaed and were the issue at the trial. And so I just want to make sure we're kind of staying within that scope, because I don't think you can file a 3850 saying you should have asked for all these witnesses. We set a hearing because the 3850 gets granted for a hearing based on what's in that motion and not unless there's some sort of amended, and then I'd have to make another ruling as to whether or not the amended is sufficient. I just want to make sure we're staying in the right scope.
Yes, sir. And this is, most of these witnesses are listed specifically within that little subsection where he lists particular witnesses.
Okay.
In fact, I'm not calling some of them because I've talked to them and I've told them about the issues pertaining to that, and we're not calling those particular witnesses. One of the ones that's not listed is addressed within another subsection of his 3850, and has to do with the juror, and I will either locate this particular juror or not, and elicit testimony from her. I've not yet been able to discuss with her, so I don't know what she's going to say, but
Tell me how calling a juror to a post-conviction matter is. It's something I've never heard of in my 20-plus years of doing criminal law.
I absolutely would agree with that, and not only that, but it seems that most of the particular issues were borne out in the transcript. I think some of the confusion stems from the transcript itself. There may be some ambiguity as to whether or not they're referencing this particular juror or not. I have some of the lines with respect to the transcript itself, and I've gone over this with Mr. Mosley because I initially had been in alignment with his position, but after reading it again, I think that they're actually referencing another juror. But I can understand why he would be confused about that.
What's the issue with the juror?
Whether or not that person,
Something to do with hearing witnesses talk or something like that?
it's not actually that issue, but whether or not she believed that she would need to hear from Mr. Mosley testify on the stand saying that he wasn't, she would need to hear testimony from him before she could make a determination as to him being not guilty. And I don't think that she was actually referenced, but it's not altogether clear on the transcript itself. I think that they may have been talking about someone else, but they don't address her by name. And that's his issue.
So what would that person's testimony be, potentially? I mean,
If I can find her, and again, I have not yet spoken to her, Judge, if I can find her, and if she in fact did not believe that she could be fair and impartial, then perhaps she should have been removed for cause.
I understand, but I mean, whatever happened, happened. Whether they should have been removed for cause or not should have been based on what was said during the course of the jury selection, right? What she says now, I mean, this trial was in, what, 2017. I know not a lot of people have a lot of jury experience as citizens, but I can't imagine she would remember exactly what she said 8 years ago. So the transcript is really what's important, not what she says she thinks she said going forward, right, Mr. Mosley? I mean,
Yes, sir.
I know we talked about this a little bit, but I just don't know if delaying the case further to try and track down a juror to ask her, hey, do you remember what you said, when we've got a transcript of it, really matters. It's not what she thought at the time necessarily. It's about, was your lawyer deficient or ineffective by not pursuing any relief on your part based on what was said at that time. But
Yeah.
I'm going to confer with Mr. Harper. I know I kind of directed that at you specifically, but
So where did he try to switch it?
Mr.
Judge,
Harper, I think I found the transcript of the trial. Can you indicate what page you think that discussion might be on?
105.
page 10, do you have it?
105. Yes, sir. That's it.
Let me read it real fast.
22. Started 22.
The trial was actually April 10th, so exactly.
At the end of page 105,
I'm just going back to kind of put it a little bit more in perspective.
and I apologize, I have to reread this.
this potentially Ms. Ramos that we're talking about?
Yeah, and my issue is,
I went backwards and I read the first part of it to see kind of where this questioning started with a different gentleman.
and at the end of 105, it started with some other individual, and then it transitions to Ms. Ramos. However, I think, and again, I'm just trying to interpret this, I think someone else answered instead of Ms. Ramos, because if you look at 106, line 11, I think that was Ms. Philbrook.
Yeah, it says thank you for that, and are you Ms.
So I don't know for certain if that was that's the point where I addressed Mr. Mosley, and I was like, I understand it might be confusing, but I think is someone else, and that ultimately that person was not put on the jury. But I can understand why there may be some degree of confusion, because Ms. Ramos is definitely mentioned. And what I spoke to Mr. Mosley about is like, I will do my best to find Ms. Ramos, to find out if this line of questioning, and I can show her the transcript, if she recalls that, and if she doesn't, then she doesn't.
All right, let me take a look at this again.
Your Honor, may I say something?
Let me just reread this again, Mr. Mosley, and I'll give you all the time you need. I just want to make sure I've read this first so I know exactly what we're talking about. It would appear to me from the transcript that the person who gave that answer that starts on 106 and goes on for about, on 105 and covers about the first third or so of 106, it's Philbrook, not Ramos. Did either of them end up on the jury?
Miss Ramos did.
Ramos did, but not Philbrook. And I think Philbrook was,
If you look at the next, after that answer, then it says, so defense counsel says, thank you for that, and are you Ms. Philbrook? Prospective juror, I am. Mr. McKinney, is there anybody else that feels the same way as Ms. Philbrook? So that long part about what that person said is not Ramos. So if that was said by someone who was not on the jury, I think we can focus on who ended up on the jury. So there was some issue that someone was not struck for cause, and that ran out of challenges. I don't know. I haven't gone through the graphic details of the jury selection at this point because we're not at that phase. But I just want to make sure that we're all talking about the same thing. That's kind of why we're having the hearing today, so we can flesh out what the issues actually are, as opposed to subpoena a bunch of people again to have them sit here for a long portion of time and not be needed. So that's why I'm just trying to narrow this down as to what the actual issues are. Mr. Mosley, you said you wanted to say something. Obviously, I'm not requiring you to, but if you'd like to, you can speak with Mr. Harper first. But I don't want to stop you from speaking, but I also want to make sure you understand that you're not obligated to tell me anything else at this point.
with the exception of that particular juror, Judge, the others, the doctors that we referenced earlier in the earlier hearing, and there are two other independent witnesses. And I would agree that they may have testimony that would be of value potentially.
Okay, so give me the names of the people who you expect, well, give me a list of names that are potentially going to be called, because obviously I'm not going to force you to call them if you list them today, but just so everyone's on the same page.
Dr. Lynn Keefe.
Okay.
He's referenced specifically in his 3850.
Okay.
Dr. Zaher, that was, if the court may recall, about the CAT scan issue.
What's the last name? How do you spell that?
Caher. And going off the top of my head, Judge, it might actually be Al-Shazali. It's one of those doctors. There was a transition period. One of those doctors was the
One
primary.
was going off shift and one was coming on.
Yes, sir. And whichever one doctor that is that's pertinent, I will subpoena.
Are they discussed in the 3850?
They're both discussed. We don't need both of them. Another witness is Michael Farnham. He was actually present the other day. I have located and subpoenaed him. And then the last witness is Joseph Dearden, also referenced in the 3850. He's the individual out of Alabama that we had some difficulty effecting service on. But we do have an address for him. We've located him.
All right, so is that the entirety of it? Basically 4 witnesses, one being not sure which doctor, but.
And again, I would like to state on the record that I understand the court's hesitation. Perhaps that's not the right word for it, but and because I share that concern about the juror, I will tell Mr. Mosley that I will do my best to locate this juror, notwithstanding that, just to talk to her, just so that he has some degree of closure on that particular issue.
I think that's all based on what's said there, and if the person who said the things that are certainly more objectionable never ended up on the jury, I just think it's a kind of a moot point that doesn't need to be discussed any further, but I'll certainly let you make any arguments.
And we can address that through Mr. McKinney if he has some specific recollection of that issue anyway. Okay, I think we just need a date that's mutually agreeable to the parties.
How long do we think it's going to take? I'd rather set aside more time than not enough, so we're not trying to do this on 2 different days. And frankly, I'll look for days that we can kind of put it on its own docket, so we're not having everybody sit around waiting for other cases to finish, and we can devote all the time needed for Mr. Mosley's case.
No,
Very extreme.
we're pretty concise and
All right,
What happened?
and what do you think as far as time frame you'd like to put it? I don't want to put it too fast and you can't affect service on people.
Yes, sir. I'm going into,
My concern is with 2, potentially 3 different doctors that we've talked about and what their schedules are. Probably needing to put it out a little bit of time.
I would say if we could get sometime in May. The only issue with that is that trial cycle-wise, I know that Mr. McKinney is with Judge Stone, and that's when they're starting to do their pretrial and all that kind of stuff.
They're in trial right now this week.
actually, we finished one yesterday, Judge.
Yeah. Problem is, as far as May, that's April. May, I have 2 trial weeks, the week of the 12th and the week of the 19th, so I can't obviously schedule anything at that point. There's a good chance there'll be a day available since, even though I set 24 trials last time, all of them washed out before we ever got to a trial. But I expect at least one to take up an entire week, that period. So I'm not sure I could potentially even look at those days. I could potentially do is I've got 2 civil trial weeks in June, which are the weeks of the 9th and 16th. I could put you on one of those Fridays because I know the ones that I've only got one set for each week. One is supposed to go 3 days, one's supposed to go 4. So I could have those Fridays open, which would be June Friday the 13th or Friday the 20th.
I don't know about Ms. Bossel's availability. I would like the latter week. I'm going to be out of the country during that first.
Okay. So June 20th is sufficient.
I think that should be fine.
As long as Mr. McKinney is available, and I can inquire before then.
And we've got time this morning. If you want to try to reach out to either Mr. McKinney or any of the other potential witnesses to confirm, we can always adjust.
June 20th, that works for me.
Let me double check.
My duty week, it'll be just extra fun, no problem. I'll see if I can get Mr. McKinney.
Want to try to reach out to him and to confirm, or just go ahead and set
I'm
it?
actually just
And,
texting him, Judge. I'll see
Okay.
if, he's usually pretty good about it if he's near the phone. He'll answer. I don't see anything for Division 2 that day.
Would that be in the afternoon, Judge?
no, I can do that in the morning. It'd have to be a little bit later in the morning. I've got. Probably have some dad duty that morning because Sarah's not working on base that day. So
Your Honor, Mr. McKinney said he's available.
all right. So let's tentatively set that for June 20th. It's a Friday at 9:30. We'll plan for 4 hours, but I don't expect that anyone's going to be looking to schedule something at 2 o'clock on Friday afternoon other than this at this point. So I'll plan that we can go as late as we need on that, but I would like to limit it to the 4 hours if that's what you think you need. All right. If you can do a notice of hearing on that, Mr. Harper.
Yes, sir.
We'll set it aside for that purpose. Frankly, that's the first time I think I really have available that we wouldn't potentially run into some other issues if we went past 3 or 4 hours that I can give at this point. I'm sure things will clear up sometime before then, but we can't really expect that.
Yes, sir.
All right, so June 20th,
June 20th.
9:30.
Yes.
Obviously, if anything else arises between now and then, and we need to throw it on another docket to discuss whatever particular issue, if there's a need to continue it, if it's a witness availability, it's a Zoom request or whatever.
Yes, sir.
Just follow the rules on that, and we'll hear those as quickly as possible.
Sir.
Anything else, Mr. Mosley?
Yes.
Again, I'm just trying to make this, we have one good shot at it, as opposed to keep coming back and trying to redo things over and over. But I think this is the best way about going about it at this point. Because I think this motion has been pending for quite some time. All right. Thank you, Mr. Mosley. We'll see you back on June 20th.
Judge, that's all I have this
All
morning.
right, thank you.
What's the thing with the cats?
And I don't think we have anything else until 12:30.
I think that's correct, Your Honor.
Is there a pretrial detention hearing?
There's
today?
3 of them.
Okay, I thought you said 1:30, that's why I was.
No, I said 12:30.
Okay, okay. Nothing from us, Judge,
All
thank
right,
you.
then we'll be adjourned until 12:30 for pretrial detention.
You happy with the championship, Your Honor?